Today, we're going to be talking about trade secret insurance. What is it? What does it cover? What do we have to do to underwrite this risk? What are the triggers, et cetera, et cetera? We are not going to read the policy wording in any kind of detail, but we will talk about fundamentally how it works and what it's designed to do. Thank you. So we are the world's first trade secret insurer. And so when we say, what does trade secret insurance do and why are we doing this? We feel that the need is really rather urgent for companies to finally start focusing on this for a lot of reasons. And I would say that we kind of divided these into two different categories. One is environmental drivers, and the other one is for legislative and regulatory reasons. When I mention regulatory drivers, environmental drivers, we're talking about kind of what's going on in the economy and culturally. And a few bullet points here kind of state why we're concerned about this and think that companies should be concerned. There was a Visual Capitalist article that came out just 3 or so weeks ago now talking about the R&D spending of the top 10 companies in the NASDAQ in 2022 alone increased 30% year over year. That's a massive increase in the amount of R&D spending that companies are seeing or putting forth because of the way the economy works today. And that is that everybody's trying to innovate. AI and other things have pushed companies to try to get things out the door quicker and quicker. And as a result, organizations are spending record numbers on research and development, which is where a lot of trade secrets live. By the way, that 30% year over year increase for the top 10 companies in the NASDAQ is $222 billion. So we're talking some very significant value in these intangible assets. And as you can see by the graphic to the right, we're trying to demonstrate that as of now, really, the insurance market only insures sort of the 10% of the assets that are above the line and above the line on the iceberg, and that all of the intangible assets that are really driving our economy today are below that iceberg, the intangibles, and the insurance industry has not done a good job of finding a way to cover the value of those. If you believe the Ocean Tomo and other statistics that are out there today, those numbers are now that 90% of the S&P 500 is valued in intangible assets, and the other 10% is tangible. Even if those numbers are off by 15%, it's still a staggering multi-trillions of dollars of opportunity here, and frankly, threat and risk to companies that have a lot of intangible assets. The second thing, culturally and environmentally, is that the Five Eyes, which are the US and our 4 closest allies in the fight against cybercrime, actually presented to Congress a couple of weeks ago as a united front for the first time ever, imploring them to do something about the threat from China, who is after our trade secrets specifically, particularly within critical infrastructure industries like everything from green energy to electric vehicle technology to space technology and drones and defense contractors. They want to know what we're doing. They don't want to have to spend the money on R&D themselves. They want to copy it and start from, not have to start from scratch. And so not only is it a threat to our economy, but in my opinion, it's a threat to our safety as a nation that we keep some of these assets secret. And there hasn't really been a lot of regulatory requirement to do so. I do think that's changing, and we'll talk about that in just a second. There is a really challenging patent environment, and so a lot of organizations are looking to other ways to protect their intellectual property assets or their innovation assets. It's difficult and expensive to get patents, especially if you're filing in multiple jurisdictions around the world. It takes a long time to get patents approved, and even then, they can be turned over at the PTAB or challenged by people who aren't even using the patents. And then your only way to defend yourself is to litigate. Or defend yourself in litigation, and or assert your rights going out the other way. So there's a lot of challenges right now in the patent environment, which is why a lot of organizations are looking to do something different with these types of assets. And then on the regulatory and legislative front, certainly we are all watching very closely what happens with the FTC's proposed federal ban on non-competes, which they're going to rule on in April of 2024. They got 27,000 public comments when they put out their proposed ban, most of them in favor of actually banning non-competes, but there was a huge contingent of mostly employment and some other intellectual property lawyers and big corporations, of course, who don't want non-competes to be banned. And so the FTC extended their time to evaluate what they're going to do, and they're going to rule on that in April. But regardless, there are now 5 states in the US that have bans on non-competes. Why is that important for trade secrets? Because a lot of non-compete agreements have non-disclosure agreements in them about trade secrets and other corporate confidential information that you have access to when you work for one company and you're leaving to go to work for another. Corporations, frankly, have potentially been overreaching in their ability to protect those assets by using non-competes as a hard hammer. And if those go away, they're going to have to rewrite and rethink the way that that works and create new non-disclosure agreements that aren't de facto non-competes, according to the FTC. And they're only going to have 6 months to do. Every company in the United States is only going to have 6 months to do that from the date that the rule goes down, if it goes down. There's a lot of discussion about whether or not it's going to pass, and it certainly will be appealed, but it's just something to really think about and take seriously. The second thing is that the SEC just came out with a cybersecurity disclosure rule. Why is that important? Because in that rule, they are finally looking at assets that are not personally identifiable information for some sort of regulatory scrutiny. I believe that it's in backlash or as a result of particularly SolarWinds and Okta, because both of those organizations had very significant breaches that either as vendors who had access to corporate confidential information or otherwise were all about sort of the aggregation, massive exposure that exists around technology that provides services and visibility into organizations that have assets that are not PII or PHI, but rather are corporate confidential information. As a result of those breaches, both organizations had very significant drops in their stock price. And I think that really caught the SEC's attention to finally say, hey, we need to tell companies, public companies in the United States, that if they are, if they have significant material assets where if compromised could lead to a significant impact on their financials at any point in the future, they need to be disclosing that to their potential investors, or else how can you make a proper investment decision? So this puts the sort of risk squarely on the shoulder of boards of directors, finally. I've been sort of predicting this for 3 years, but I think this is really what's happening. In their actual commentary about the rule itself, they said their perception of something that would be material, that would require the immediate, within 4 days, filing of an 8K, is anything that could damage your reputation or your competitiveness in the market. And so, yes, not everything in R&D or not everything that is being developed, every innovation asset is a crown jewel trade secret per se. And so it might not be a game changer if it's disclosed and now other people can use that asset in their development of whatever products they're selling or manufacturing. But the crown jewel assets of a company certainly would have a material impact, or could, on future earnings if you no longer can protect those as trade secrets. So I believe now public companies are going to have to identify trade secrets with some specificity and be able to demonstrate in their 10Ks what they're doing to protect those assets, including the use of consultants and training materials and hiring, firing, all of those kinds of things, which we build into our process. So that really bleeds into the next point, which is, that I think the D&O exposure is on the rise and that boards are going to be asking about this now. Next slide, please. So when I mentioned that we look at hard at this in our due diligence process, what we are trying to do is not only provide ourselves with a good benchmark and thorough understanding of how companies are identifying, valuing, mitigating their exposure to trade secret misappropriation. So we do that as part of our due diligence process, but it's also, I think, a really valuable service that we can provide companies who don't know where to start, or maybe have gotten a little bit of a start but need some help in understanding what, sort of trade secret law says are kind of reasonable measures, what would be expected from training, non-competes, non-disclosures, all of those kinds of things, how to identify something that could qualify as a trade secret in the first place. And so we've developed this whole risk management process we call Crown Jewel Protector, um, because we found that most companies don't have a formal process yet to identify their trade secrets separate and apart from other types of innovation or intellectual property assets. And I think that's going to dramatically change. So with the development of this process and the fact that we essentially use it as due diligence, but give these tools to clients as part of the process, we were able to get capacity. That's how essentially we've been able to get our capacity in the market, is to convince the underwriters that this can be written on a profitable basis, if the client is doing all of the right things. So once we put the insurance in place, we're comfortable with the mitigation procedures, and the client has documented via blockchain, which is a requirement from us. We provide either the blockchain software or they email it to us as an NFT, so that we have affirmative forever evidence that they were developing the trade secret or the innovation asset themselves. Independent development is a huge component of a trade secret, so that we can use that if we ever need to sue or subrogate or any of those fun things, when there's a loss. And then following a misappropriation or a suspected misappropriation event, we cover the cost to hire a legal defense team, to put proper policies and procedures in place around protecting privilege, hiring the forensics team that's going to come in and do an investigation to determine the source and scope of how the trade secret or secrets went missing, which is a big part of what we want to do early on in the case. So we provide the sort of breach response, if you will, around the theft or suspected theft of an asset. We try then to use whatever measures legally we have under various trade secret laws to get the asset back, using ex parte seizure orders, or we get an injunction or a temporary restraining order or file for expedited discovery, any number of those things to try to sort of prevent the bleeding in the first place, or stop the bleeding before it, gets to be actual trade secret losses, which are economic damages, which we'll talk about in a second. And then if we're not successful at that stage, then we pay out the fair market value of the asset, and then we turn around and subrogate if we feel like we have a good case and there's a deep pocket for us to go after. All really important components to what we're doing from a risk mitigation standpoint. So just a quick summary on what the insurance is, and we'll talk more in detail on the next two slides about how it works and what it covers. I know we've got some very specific, I apologize to the very loud noise right outside my window. But the trade secret insurance really attempts to cover the value of a trade secret as though it were a building or another tangible asset. And by putting a value on that asset, we can then schedule it on the policy at that predetermined fair market value, which is given to us by an independent accounting firm. We have several of them on panel, that instead of looking at a whole portfolio of intellectual property assets like they might do during a merger or acquisition situation, we are actually going to them up front and saying, this client has 3 crown jewel trade secrets that they want to insure, meaning that these are innovation assets or know-how that they've told their investors about, they've spent a lot of time and money on, they're putting the extra protections around to keep them a secret because that provides competitive advantage for them, the secrecy itself. All of those things are components of what makes something a trade secret. And once we go to them and say, okay, they've got 3 crown jewel assets they want to cover on this policy, then they will fill out a questionnaire and then go back and forth with the valuation team on putting a value on those assets. And we schedule that value, which changes at renewal. So once a year, but it's kind of something that we and the insured agree with and everybody lives with for a 12-month period, even though we know that trade secrets really go up and up or down theoretically in value over the policy period. We intentionally, very intentionally stayed away from having a policy that pays for kind of actual loss sustained like a business interruption policy would, because we felt like we would end up litigating every time there was a loss. So we avoided that like the plague. The next bullet, we've got $16 million in confirmed A+ Lloyd's backed capacity. We are currently adding more capacity to that. And we'll continue to do so over the next couple of years. Obviously, with any brand new industry vertical or insurance product, the carriers want to see losses before they're willing to jump on board, or they dip a tiny toe in the pool and then they'll expand their capacity as the demand grows and we can confirm and validate that the underwriting and pricing is working properly. But there are a lot of brokers out there who believe they can get significant limits over and above our 16 million for their clients, just using their own relationships and the IP, traditional IP or cyber markets, or even property markets potentially, to go find additional capacity. By valuing the insurance or valuing the assets and putting insurance behind them, one of the things that we like to say is we think that we are going to create a whole new ecosystem for trade secrets, for the monetization of those assets, because today companies don't do anything really with their trade secrets except for trade on them internally. They could potentially, if they're ultimately a product or process that they're selling to their customers, then maybe they're monetizing it in that sense. But a lot of trade secrets are negative know-how that's just a learned process that they've developed themselves over years and years of trial and error internally. That negative know-how is a significant part of the value of a trade secret, not something that you sell your client, but rather it makes your manufacturing process, more reliable, and you develop less scrap and it's quicker, or your logistics and supply chain function is the way that you beat your competitors on delivering packages or services faster than your competition. Those are all really valuable things that are trade secrets, or can be, that if you put a value on them and you insure them and schedule them on an insurance policy, you should be able to get loans against them, or attract investors who otherwise would not be interested in your company, because maybe you're an innovation only company, you don't have any tangible assets to use as collateral, and you're not cash flow positive. And so it's hard to raise capital, and certainly even harder to get a loan in that scenario. But what we're doing here is making it so that this works a lot like property insurance would work for a mortgage lender, in that they will loan all day long on properties on the beach as long as there's wind and storm surge, coverage for their cat exposed locations, because they know in order to get that insurance, they had to have proper construction, occupancy, et cetera, et cetera. This is the same exact concept. We recognize it's going to take a while for this to take off, but we see that as a really valuable outcome of this in the future. It also provides visibility to the directors and officers around the disaster recovery and crisis management strategies for these really valuable assets. A lot of board members are not thinking about this, and they could get caught very flat-footed if there's an investigation around something that goes amiss when a major, critical, important asset walks out the door and they didn't know what it was worth or who had access to it and don't have a plan to get it back. And then finally, just to let you know that we do have available this coverage that does not cover the fair market value of the asset, but provides only the crisis management coverage. So it's kind of an insuring agreement, first insuring agreement only part, where we do the forensics and the legal part to try to get the asset back or stop the bleeding, but we don't actually pay the value of the asset. Leading to this slide, what are the two? There are two insuring agreements. The first is theft response and recovery, which picks up the investigative expenses and reacquisition expenses. Basically, this is crisis management. If there is a suspected misappropriation or theft of a trade secret asset, security breach is broader than what you would see on a cyber policy. The definition of security breach is there has to be a suspected security breach for you to pick up the phone and call, use a 1-800 number to call a lawyer that we have on panel, and they're trade secret lawyers, not privacy attorneys, of course. And in that case, security breach means cyber intrusion and or just theft by former employees, vendors, whomever it is. And we have, obviously these are defined terms in the policy. Reacquisition expenses basically is where we would be trying to either get the asset back or do what I was saying before, use our trade secret law capabilities to get an ex parte seizure order, an injunction, expedited discovery, some sort of a temporary restraining order, whatever the case may be, to sort of cure the impairment and make sure that there aren't any actual trade secret losses, which is if there are trade secret losses, then it switches to insuring agreement B, and that's where we pay the pre-agreed fair market value. There are a couple of exceptions to us paying the full fair market value. One would be, for example, if it's determined that the client only suffered a loss due to the misappropriating party's unjust enrichment, meaning they gained something by not having to hire and train and make all the wrong turns in developing an innovation asset, but they haven't actually impacted their sales at all. Then we would only pay the R&D costs that went into the development of that asset, because that's equal to essentially the unjust enrichment gained by the third party. So there are some exceptions, but very few. And that's how the policy is intended to work. Next slide, Lindsay. I realize that we're speeding through. We started 5 minutes late, so I'm just going to give myself a couple extra minutes here. And I've got a little bit of extra time if you have questions. But there are a lot of nuances in trade secret law that are different than other intellectual property types of law, even, which is different than most other claims that most insurance professionals have dealt with in their careers. So I just highlighted a few of the key things that would come up in either negotiations on a claim or in the policy wording itself. Damages and losses can be either that unjust enrichment or costs avoided by not having to do all the things we just talked about. Loss of market share or income, damage to your reputation, attorneys and expert witnesses fees, reasonable royalties. And these claims are almost always brought in conjunction with some form of breach of contract, which is you breached your non-compete agreement, you breached your non-disclosure if you're a vendor or a customer who was given proper means, proper access to the asset, but you broke what you were supposed to do in treating that asset as a secret. We also talked just a second ago about what negative know-how means. That's a very important component in trade secret law, and a lot of the most valuable trade secrets in the world are negative know-how. Improper means is improper and proper means are either you gained access to the innovation by proper means, which is somebody gave it to you contractually, they had, or you properly reverse engineered something without using the knowledge of somebody who worked for the former company, or you essentially independently developed something. Those are all perfect defenses to a trade secret claim. Obviously, improper means anything else where you were you induced somebody to commit fraud, they broke their promise, you had an obligation not to disclose something, and somebody disclosed it anyway. So those are terms of art which you'll find up, showing up in the policy wording. There is a criminal element to the Defend Trade Secrets Act and some of the state laws. There are 49 states that have their own trade secret laws, meaning that somebody can go to jail. I think a lot of employees don't have a full understanding of if they take corporate trade secrets from one company to the next, there is potentially jail time associated with that. And there are very big fines for the company who hires you if they intentionally hire you away with the intent of getting at your trade secrets. And that's more often when you see multiple damages as awards on the back end, including attorney's fees if it's egregious. And then finally, another funky piece of this, which is similar in patent law, is the involvement of the ITC, the International Trade Commission, which only gets involved if there is a foreign actor that takes U.S. trade secrets and then tries to sell that asset or that innovation back into the U.S. They have the ability to say you can't do that. That just happened in the Apple Watch case, which was very, very interesting. Next, so I can fly through these and then you got, that's it. So just wanted to, I think we're good. Any questions from anybody else and or can I answer anything for you or provide additional information? Otherwise, follow us on LinkedIn, check out our website. All 6 of these, this was our 6th Trade Secret Tuesday. All 6 of these are available for replay on our YouTube channel. We have a podcast. We've got all kinds of information, but if you need anything else specifically before you can go talk internally, if you're a buyer of this, potential insurance to your own constituents, or if you want to go talk to your clients about this as a broker or lawyer, we're happy to provide whatever additional assistance we can. And thank you for your time, and everybody have a happy Thanksgiving.